All rise. The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. And welcome to this special session of the Iowa Supreme Court held at the University of Iowa College of Law. One case will be submitted this afternoon. It is in re the interests of D.S., a child. Mr. Slavik, you may proceed. Or I guess Mr. Kempkes, I'm sorry.
Thank you, Your Honor. It's a pleasure to be here today. And please, court. When does bullying by a child reach the stage of criminal harassment? When does bullying speech merit First Amendment protection? Do school children even have full First Amendment rights for off-campus speech that adversely affects a classmate? The speech here today that's being challenged is not entirely without dispute. But it seems that there's sufficient evidence to show that what was said was, "You're a fat skank," or "a fat skanky bitch, and I can get any guy I want." There's other evidence to show that said you can go die in a hole, that you're a bitch, a cunt, a slut, who fucked the bus driver. Now, whatever was said, those words were extremely offensive, vulgar, insulting, and injurious.
Well, but the statute, the harassment statute, it seems to me, requires that there be intent to threaten, intimidate, or alarm. So your vulgarity doesn't get you there. It seems to me you have to show an intent to intimidate, threaten, or alarm. So what do you have here?
Well, I'm not suggesting that vulgarity does get me there. What I'm saying is that there was an intent through the use of vulgar words
To what? Intimidate?
to intimidate, threaten, or alarm. Alarm has been defined by this court to mean merely feeling disturbed.
So any disturbing speech could become harassment?
I wouldn't go that far. I'd say that, they've got, as the Supreme Court has made clear in the First Amendment cases, that context, surrounding circumstances, prior history, all have an impact on that. Certainly the use of a vulgar word, in most cases, has more of an impact than one that's more civil in nature. And that's why I bring it up. Now, these words were shouted.
But certainly just mere name calling doesn't get us there, does it?
I would agree, Your Honor.
At what point do we cross the line between the kinds of insults that we expect people's skin to tolerate and cross over into something that is intimidating? Don't we have to, in order to preserve that line, require that the word intimidate necessarily connotes some reasonable anticipation of the person to whom the remark is directed, reasonably feel or believe that there's some risk of physical injury or harm intended?
I would agree, Your Honor.
And why is that shown here?
Well, bear with me one second. What you're saying, what you're proposing, essentially is what is in Section 729.5, which defines intimidation for purposes of violating individual rights. It says there that it's any communication intended to result in placing another person in fear of physical contact, which will be injurious, insulting, or offensive, coupled with the apparent ability to execute that act. I think that's essentially what you said. Now, I think one of the mistakes that was made, not only by the Court of Appeals, but by the juvenile court in this case was that the focus was on the effect of the words upon the victim. If you look at both decisions, they talk about how the victim responded to that. The statute, however, is a little different. The statute talks about the intent to threaten, alarm, and intimidate. And that's where the history of these two girls comes into critical play. The history shows that there was 10, and this was not disputed by the child in her own testimony, that there was a 10-year period of bullying behavior on the part of the child. Bullying behavior that included baiting the victim into fighting her, trying to bait her into fighting her.
How do you distinguish this from our State v. Bowers case? You know, in State v. Bowers, there was a statute that said, any person who willfully prevents or attempts to prevent any public office or employee from performing the officer's or employee's duty commits a simple misdemeanor. And the gentleman was arrested and convicted because he was yelling words such as these words to the officer while the officer stopped somebody. And we said we have to construe the statute to be constitutional, and in doing so, the only way we're going to construe it constitutional, there has to be either fighting words or physical conduct. And fighting words is defined by the United States Supreme Court. Don't we have the same duty here to define this statute constitutionally?
Well, you do, Your Honor, but one of my points that I hope to be making a little bit earlier was that there is no constitutional issue preserved for review in this case. If you look at pages 6 and 7 of the ordinance, it sets forth the child's motion to dismiss. In that motion, the only constitutional argument that is raised is that her words were not true threats.
But construing a statute to be constitutional is a rule of construction, not an error preservation issue.
Well, it does come to error preservation, Your Honor, because it comes to law of the case. If there is no proper constitutional challenge to this, and as I'm going to argue, there's no statutory issue properly presented, the law of the case is you must accept.
So we should disregard the Constitution and construe this statute in a very broad way like you want us to do, and then the next time around, if someone raises the constitutional issue, we have to reconstrue it?
No, Your Honor, that's not what I'm arguing at all. What I'm suggesting is, and I really hope to finish my thoughts on this because I think it'll become clear. There's no constitutional issue because the only argument that was made was there were no true threats that were made by this particular child. Okay? She did not argue there was any fighting.
But that's a constitutional issue without saying constitutional, because the constitutional test is fighting words. And that's what he's saying. There's no fighting words there.
No. The argument that was made was there are no true threats. That's a separate and distinct concept than fighting words. That was the only thing mentioned in the motion to dismiss. That was the only thing the juvenile court ruled upon.
But isn't that just a subset of the whole string of cases that we're talking about here?
I don't believe so, Honor. I think this court, as well as the Supreme Court, is viewed as a separate and distinct exception to the First Amendment.
But it's one of the exceptions of a string of exceptions, but it all falls under the veil, doesn't it, of whether it's protected speech or not?
Well, that might be the case, but she bore the burden to negate every conceivable basis upon which the statute could be upheld under a constitutional challenge. If you only challenged the true threats, when it could fall within fighting words, you've only made half the argument. That's my point. The juvenile court never ruled upon any fighting words issue. Not at all.
Did the juvenile court rule on a constitutional issue?
It just summarily denied it.
Well, so there was an order on I think the juvenile court's order expressly denies or overrules the constitutional challenge.
But the constitutional challenge was only half made. It could have decided it on the grounds that no fighting words argument was ever made. This is where I come into the statutory construction argument. If my argument is, first, there's no constitutional issue that needs to be resolved by this court. Second, with regard to statutory construction, if you look at the appellant's brief, nowhere in there is there a statement that the juvenile court erred in construing the word intimidation. There's nothing in that. But even if you looked at all four corners of the brief and concluded, well, we'll say that the issue was raised, she only went halfway again. She said that juvenile court erred in construing the statute, but she didn't say what the proper construction was. So you don't even need to construe the statute because she hasn't preserved statutory construction issue.
Let me ask you, Mr. Kempkes, you talked about the alarm prong of the statute, which in Evans we construed to include just to disturb. And that was the foot fetish case where the person was asking a woman to take photographs of her legs. It was sort of unwanted approaches, but there was no threat of physical harm there, was there?
Not that I recall.
Now, could we affirm what the juvenile court did on the basis of finding that there was an intent to alarm?
Yes, Your Honor.
Even though it looks like the juvenile court did not use the Evans definition of alarm in its decision.
Correct, and that's what I've argued in the application. I'm actually arguing all three prongs, that they could find there was an implied threat here, that there was alarming behavior or intent to alarm, and that there was an intent to intimidate as well.
So intent to alarm means to feel disturbed. Isn't that what name calling is all about? I mean, you name call, the reason you call someone epithet of some kind is to disturb. You wouldn't, right? So wouldn't all name calling then be harassment under your interpretation? Maybe that's sound, but
well, it's not my interpretation, Your Honor. It's this court's.
Well, I understand, but for this court to say somebody calls a youngster a nasty name, it is done with a desire to irritate. I mean, by and large, you don't call people names unless you're trying to sling an arrow of some kind. So, really, all playground name calling would be within the scope of the statute.
Well, I wouldn't read it that broadly, and I'm not making that argument. I'm arguing under these particular circumstances, and given what we believe the word intimidate to mean, or alarm to mean, that the conduct falls within that statute. Again, I don't necessarily agree with the juvenile court's constructions of intimidate. I think it's close. I think it's got the nub. Intimidation implies kind of a disparity in power and strength. And you're trying to overawe or cow somebody to do or not to do something.
Counsel, aren't we going to criminalize too much speech if we don't have a bright line rule that would require some sort of threat of physical harm?
First Amendment cases are I've found out in the last few months, notoriously difficult to categorize and establishing bright lines. Certainly it would be beneficial to the bar and to the general public to have a bright line. I don't think it's necessary in this case. I think it's sufficient for you to hold that under these particular facts and circumstances that the conduct involved was violative of the statute.
Would this case then stand for the proposition that mere name calling that does not induce a fear of physical harm can be criminalized? Well,
I don't think there was mere name calling here. Again, this is where the history of the two girls comes into play. It's part of a pattern of intimidation by the one girl against the other, and critically it involved prior physical abuse. I don't think it's just somebody passing on this, excuse me, sorry.
But this isn't a practice of practice or a crime of practice or a consistent pattern of behavior. That's not what the statute really says. It's not a statute that really involves a pattern or practice of behavior like we see in some of the other criminal statutes. This is a pretty focused and isolated type of definition under the harassment statute. So what effect are we to give to the history and the prior history between these girls if we need to look at this just as an isolated incident? A criminal act, this being a criminal act for which she was adjudicated.
Well, Your Honor, first of all, the cases that I've cited in the application for further reviews say, in fact, that it is relevant. That's number one. Number two, there are other cases that deal with spousal abuse, that deal with sexual harassment in the workplace. They don't look to a single point in time and focus on those words and say, oh, that is or is not harassment. The full flavor of those words can only come into play when you know the history between the speaker and the listener, as in this case. There's been no facial constitutional challenge to the statute. The question is whether this girl's words were intended to intimidate, alarm, or threaten.
Mr. Kempkes, is there an overbreadth challenge in the case?
No.
Counsel, on that point that you just left prior to the question from Justice Mansfield, you've emphasized the history here, but isn't it significant that the district court made a specific finding that I'll call her the victim in this case, wasn't really in fear subjectively, and following on that, the witness who comment on the witness who testified that she observed the immediate aftermath of the exchange, and it was her assessment that the victim's reaction was just, well, this is just another day. This goes on all the time. It's not a big deal.
Well, first of all, Your Honor, there's no requirement in the statute that there be actual intimidation, alarm, or fear on the part of the victim. Again, I think the juvenile court, as well as the Court of Appeals, lost focus of what the statute requires in terms of the intent. That's number one. Number two, she may have stated that she wasn't in particular fear at this moment in time, but her testimony was that she had been bullied nonstop for so long that she feared walking home alone. This was before that incident ever occurred. And lastly, the neighbor's testimony is, I think, can be easily explained. Whenever we're embarrassed in public or embarrassed and somebody overhears it, you know, I tell my child, sticks and stones can break your bones, but words can never hurt you. We want them to think, oh, well, no one's hurt me. I'm just going to, did they bother you? No, they didn't bother me. So the neighbor says, interrupts and says, did I hear what I just heard? Yes. And she didn't appear upset. She didn't want to appear upset. I think what really matters is when she goes home and she's by herself and she breaks down in tears and contemplates suicide.
Well, it's the intent. I mean, I think you made a valid point. The issue here is whether the actor had the intent to intimidate and alarm. I mean, she may well have gone home and had some adverse effects, but I think the focus, under the statute at least, is the intent of the actor. And I get your argument. I mean, I understand your argument that you don't just take the words at a certain point in time out of context. There is a relationship that, over time, that you need to examine to understand the intent behind the words. And you indicate there was a fight in the past. But the fight wasn't the day before, I don't think. Make your best argument as to the nature of the stream of events. I mean, I get your argument about you got to consider the context, and what happened before is irrelevant to determine the intent today. But make your best argument that, for example, the fight sheds light on what happened in this case, even though the fight occurred a substantial period of time before.
Well, first of all, Your Honor, time is a relative thing. For somebody 6 years old like myself, 2 years seems a long ways away. You're in junior high or high school, and you've been beaten up. I think 2 years is a relatively short period of time. You don't forget that. Second, that was the most recent fight. We don't know how many times she was, the testimony from the victim was that she was constantly being baited. Fights were constantly being welcomed, initiated by the child, by the delinquent child. So I think in this point in time, it was she had reacted in the past, the victim, to try and show that she wasn't as weak as the other girl thought she was. And at this point in time, she didn't do it. She didn't stand up to her. I think, from the evidence, it shows that the delinquent child would have welcomed a fight. You know, her words to her was like a symbolic first punch. She wanted to engage her. And so in terms of the time element, again, I think you have to put yourself in the perspective of a 15-year-old girl who has endured this since the age of 5. You can't look upon it as somebody, as I am in my 60s, like say in my 60s. You can't view it that way.
Thank you, Mr. Kempkes. Mr. Slavik.
May it please the court. This case is about whether personally insulting somebody is a crime. I believe that the Court of Appeals properly construed the statute, particularly with the word intimidate, and that the juvenile court erred when defining the word intimidate. The juvenile court found that Ms. Stark harassed the other child by calling her names, by saying that she was better than the other child and that the other child was a slut or a skank and slept with the bus driver.
Mr. Slavik, let me ask you, let me give you a hypothetical. Let's say Jack and Jennifer go to this law school, right, and they're in a relationship, and Jennifer breaks off the relationship. Jack pursues Jennifer, approaches her repeatedly, and uses some of the words that are used in this case, some of those expressions. Are you saying that can't be prosecuted? The state can do nothing about it?
I don't think the words in this case alone reach the level of being intimidating. I think that intimidating, along with the other two words in the code, the alarming and threatening, all have to do with physical violence or some kind of physical harm.
So your view is if the goal is not to threaten physical harm, but just to get in the person's head and make them miserable, which is what this case that the state was making here, that's not enough. Is that your position?
I do not think that is enough. I think if, we have two parts of the harassment code here now. We have the personal contact part. We also have the electronic communications portion. I think if Jack and Jill were doing that through electronic communications, I think that could be prosecutable under the annoy prong. I think it... I
agree, and that's a good point. I may ask Mr. Kempkes about that. Let me frame another question. Let's say in this particular case, DS and TV, the same events happen, and TB suffers psychological harm. Could she sue for intentional infliction of emotional distress?
I think that could be possible.
But how could that be? Because if it's a First Amendment issue, you can't bring a cause of action based on it. That's what the Phelps case, the Westboro Baptist Church case, Supreme Court said, right?
Yeah, I may have been mistaken on that.
What about this alarm business? I mean, in State v. Evans, we did deal with the term alarm, and we gave it, frankly, a rather broad reading. Alarm includes to feel disturbed in addition to feeling frightened or in danger. Disturbed in addition to feeling. Okay. The that is a 2003 case. Alarm is in this statute. It seems a fair reading to suggest that your client was intending to alarm in the sense of disturb. Don't you have a problem?
I don't think she was trying. I think she was trying to annoy the other child. I don't think she was trying to annoy.
Being annoyed and disturbed. Maybe there is. What is
I think it's a difference of degree. I think disturbed is a higher degree than merely being annoyed. I think that's the distinction between the two words.
And how do we decide whether in this case this was a mere annoyance or a disturbance?
Well, I think the court could look to the effects on the child.
But I don't know about that because the statute talks about intent. I mean, I had that colloquy with your opposition, Mr. Kempkes, but it seems to me under the statute, first you have to have no legitimate purpose. We haven't talked about that. But then the other element is intent to alarm. What was your client's intent? I mean, and how do we tell whether she was intending to annoy or intending to disturb?
Well, I think we tell the difference between the intent to annoy and the intent to disturb with what would be said. Similar, the First Amendment does not guarantee an absolute protection to free speech. We have fighting words which are not protected, true threats that are not protected. And you determine that from the overall context, the totality of the circumstances. And I think you would have to take the same thing in this case. In this case, Ms. Stark, it was a very brief exchange. She yelled something which was intended to be towards her friend who had fallen behind as they were walking. The other child interpreted it as being directed at her, and then the exchange happened. And I think that shows that it was merely to annoy rather than to disturb or alarm.
What do you think of the contextual argument? I'm sorry. The contextual argument is, as I understand it, it's not just what happened on that day, and you have to consider the longer-term relationships between your client and the other child. And in fact, the history shows, albeit it was 2 years ago, but there was a fight. Well, and then ongoing problems. Isn't that relevant in terms of determining your client's intent?
Yes, I think it's relevant. I think the record is in dispute as to the history between the two girls. The record is clear that they did not get along, but there is some dispute about what if any, violence was in the past. And the record is actually completely empty of any record that my client has a history of violence with anyone, let alone the victim in this case. I think if we're in a situation where even if the fight between the two of them, if we knew for certain that there was a fight and it happened 2 years ago, if my client had gotten into physical altercations with other children, then it would be more reasonable to assume that my client was presenting some kind of physical danger to the other child.
When we've got disputed facts, shouldn't we go with the trial court's findings, and how do those help you?
I think we should go to the trial court's findings. I think it helps because the trial court, there was some dispute over what exactly my client said, and the trial court found that the victim exaggerated or embellished what was said. She made her initial reports to the police department about what Ms. Stark said, that Ms. Stark said that she was better than the other child, that the other child was a skank and slept with the bus driver, but only later at trial did she claim that my client told her that she could go die in a hole, and Judge Albee at the trial, in his order, determined that that was a recent fabrication.
Counsel, I'd like... I'm sorry.
Well, and you would agree with me, this is a specific intent crime, wouldn't you?
Yes, I would.
So it's a specific intent crime, which then goes to the idea of you can put it in some type of context to try to meet the burden of showing that there was the specific intent to do these things. But didn't Judge Albee, in his findings, literally say that there was no threats, there was no alarm, and the only real issue or the basis of his decision was on the definition of intimidate? Isn't that what?
Exactly, Your Honor. Judge Albee did find that there no threats had been made, and actually the child on page 13 of the appendix also admitted that no threats were made, and Judge Albee found that the child was not alarmed.
Well, she originally said she did feel threatened and she did feel intimidated. That was her original testimony, and then later on, I guess, under cross-examination, she backed off of that, didn't she, a little bit?
Yes, she initially issued sort of a blanket statement that she had been threatened, intimidated, and alarmed, but when pressed for why or how any of that happened, she was unable to provide an explanation and just admitted that she was not threatened.
Were you finished?
Yes, Your Honor.
Okay. I'd like to take you back to this distinction between the intent to annoy, which you contend falls within protected speech, and the intent to disturb, which in Evans wasn't protected. And that's a pretty nuanced difference, and I'm not sure I understand your distinction. I'd like to give you one more chance to explain that nuance to me.
Sure. Well, and I think there's been a few cases. Some of them were mentioned in the additional authorities cited by Mr. Kempkes, is that when the speech involves some kind of conduct, like the electronic communication, then it's deserving of less protection. When you have the conduct of using a phone or using a computer to make the annoying speech, it deserves less protection than a pure speech case. With a computer or a phone, it's mixed with conduct. In a pure speech case like this, there's more protection. Even more than that, my client was on a sidewalk when this happened in a traditional public forum. The distinction between annoying and disturbing is that you look at the fighting words, the various fighting words cases. Being annoying is protected. It's only when it rises, when that annoyance or provocation rises to the level where it's going to induce a fight or a riot or some kind of...
Well, it's undisputed that your client called the other child a fat skank, I believe.
Yes.
Is that a mere annoyance?
I think it is, because I think in this day and age, that, you know, if I were going to compare the free speech cases from the 1930s and 1940s, you look at the words that were considered fighting words at that time, they're really pretty mild insults by today's standards. I don't think anything my client said would have even had to been bleeped if it were broadcast on TV. And I think, you know, when we're talking about totality of the circumstances, one of the circumstances is the societal context, you know, the age that we're living in when this is made. And these statements, although they were insulting by today's standards, are, you know, relatively mild.
Boy, I hate to hear some severe speech.
Well, and I would point out also, and this is on page 37 of the appendix, is that my client testified that the initial thing that she yelled, T-bitch, was actually her friend who was there's nickname, which is the person she was yelling at. And she testified, my client testified that her own nickname was D-bag, and these are just how these kids talk. I think she could have been much more explicit and insulting if she was trying to disturb or alarm the victim rather than merely annoy her.
Well, counsel, what significance should we give to your client's statement shortly after the incident when interviewed by the police officer? And she characterized, she conceded or disclosed to the officer that she hated the victim. Is that significant to what her intent was at the time the statement was made?
I think it's significant, but I don't think it's determinative. I think the emotion of hating the other person just as easily supports the idea that she was trying to alarm the other, or trying to annoy the other child, rather than trying to alarm. I think it's reasonable to conclude that if you hated, or reasonable to presume that if you hated somebody, you would try to annoy them. I don't think that specifically leads to the conclusion that she was trying to alarm or disturb the other child.
Could you address opposing counsel's argument that the constitutional issue was not preserved for our review?
Well, I think as Justice Sager was mentioning before, I think these are sort of two sides of the same coin. The true threats was raised in the motion and the brief both indicate that the motion indicates that that there were no true threats made, and specifically that the speech was protected by the Constitution. The brief also does specifically mention fighting words also.
Is there an overbreadth challenge raised in this case?
No, there is not, Your Honor. When I reviewed the case law prior to raising the appeal and making the motion initially, I determined that had been adjudicated in prior cases and didn't need to be raised.
Can someone be convicted of intimidation, that prong of this statute, consistent with the First Amendment if there's a finding that there was no physical fear intended? I mean, have you ever been intimidated by a law professor?
I think it would be difficult. I think that's problematic if somebody were going to be convicted on the basis of intimidating when there's no fear of any actual physical violence. Because the same way it could be a law professor, you could intimidate somebody by convincing them that an asteroid was going to hit the planet next month and kill everybody, and that may very well place them in fear, but you're not afraid that you're going to actually do anything to them.
Counsel, was there an examination of what these terms actually meant? Was there testimony of what a fat skank, what the meaning of that was?
Not specifically, Your Honor, no.
What are we supposed to do with that then? I can remember my kids would come home from school and they would use a particular term or something, and I would say, do you know what that means? No, we just use it. And then I explained it to them and they would understand that it would be inappropriate. Was this play a part of this case at all?
It was
and
not.
I guess my question too is, to what extent does age play a role in the application of this statute? The age of the participants or actors?
I think the age is relevant. I mean, that's why we call it being childish, name calling. This is what kids do, and they're not necessarily trying to start a fight by saying these words. I think it's clear from the context. I would concede that the term fat skank, even if no specific definition was given at the trial, that it was meant to be an insult.
Thank you.
Thank you.
Rebuttal, Mr. Kempkes?
Thank you, Your Honor. I'd like to reserve, if I may, 1 minute of time to summarize the state's position, and before then, I'd be happy to answer any of the questions that I'm sure you have for me.
Oh, I've got one.
That's a surprise.
Would you agree with me that alarm, whatever it means, needs to probably be interpreted as something more than annoyance? If you juxtapose subsection A and subsection B.
My answer to that is twofold. One, I believe there are other statutes in other states that have upheld the use of the term annoy in their statutes. Courts have upheld those under various challenges. Two is, I think there is more than mere annoyance here. I think it's clear that there is an intent to disturb. I can't think, I'm not a teenage girl, but I can't think of anything worse than being called a fat skank. Those are words that are intended solely to humiliate, to wound, to hurt, to injure. And I think, Justice Heck brought up a good point. There is evidence here that the girl hated the other girl. And you will say things to people you hate more readily than to people you have a mild disagreement with. I think you can infer intent. I agree with my opposing counsel that you can infer intent on the basis of the totality of the circumstances. Part of that involves, and I'm not saying it's critical, but part of that involves what is the effect. That does have relevancy. Here it had a twofold effect, not just upon the child who went home and cried, contemplated suicide, but the neighbor who hears it being shouted on her doorsteps. She's shocked by what she hears. She can't believe it. So I think when you look at the terms that were being used, in the context, they did fall within the statute. And I also agree with counsel when he talks about you have to look at this in terms of not only who is the listener. I mean, they say it's an objective test under Chaplinsky, but it's really not. Because you have to look at who is the listener, who is receiving this. Certainly a racial epithet would have a much stronger impact upon a minority, and therefore the intent to disturb, alarm, and threaten could be readily inferred from that.
Counsel, if we reverse the conviction in this case, to what extent should we be concerned about undermining anti-bullying statutes?
Well, I think that'd be significant think this is a perfect case to send a signal that, you know, the state of Iowa isn't going to tolerate behavior that goes beyond that line. Where that line is, it'd be great to be able to say, this is a bright line, but, you know, these are fact-specific cases. And I think the best that can be done.
We can't criminalize protected speech, though, if we find so. I mean, you just can't.
If you find it's protected speech,
yeah, we
correct.
can, you know, the legislature could try to do anything they want, but they can't criminalize protected speech either, can they?
I agree 100%, Your Honor.
So is fat skank protected speech under our First Amendment? How does that advance a free marketplace of ideas?
Well, it doesn't. And, you know, there are countless law review articles talking about the different levels of speech. Some involving political discourse are at the very highest. Here, they're at the very lowest. There's absolutely no legitimate purpose in calling somebody a fat skank under these set of circumstances.
Well, the Supreme Court held protected speech when people yell those types of epithets at police officers.
Well, again, that's
protected speech.
That's where we come into an objective test with a subjective component. You look at the State v. Fratsky case, same thing. You don't look at it from the terms of an average person. You look at it from the terms of an average state trooper who was the recipient of the speech.
How old were these participants? 15? How old were they?
15 years old, both of them.
Well, does the interplay between protected and unprotected speech, the fine lines that can be drawn, should we even be applying it with kids that are 15 years old?
Are you? I'm not sure what you're asking, Your Honor. Can you rephrase it?
Are we asked to apply a standard that we should expect them to understand and apply in their daily lives?
Well, you know, they're expected to understand the standards for first-degree murder, sexual abuse, every crime, Your Honor. And I guess this is no different. I guess that's my response. If I can finish up, I'd like to say that, you know, every institution has its sage. Hogwarts had Dumbledore. One of the sages here was Professor Bonfield. In 1977, he told my constitutional law class, the First Amendment doesn't protect a fist in the face. Well, a fist in the face is typically, historically, what men and boys have used to intimidate people. But hurtful words, that's the weapon of choice of teenage girls. And it's particularly effective when it's combined with a long campaign of verbal abuse and past acts of physical violence. It can drive a teenage girl to suicide. And I'm going to ask, is this case any different if this girl had committed suicide? And the answer is, it shouldn't be. Our court system should play a role in protecting children from harassing conduct that all too often results in terrible consequences. Perhaps more than any other state court, this court has a long and proud tradition of being in the progress of various issues. More than 150 years ago, it protected the rights of Ralph, a slave, long before the Civil War. In the past couple of years, and even yesterday with regard to oral argument, this court has been led the way in taking a strong stand against equating juvenile offenders with adult offenders. So today, it has the opportunity to protect the most vulnerable members of society without infringing upon any First Amendment rights. It's possible. It can be done. If there are no other questions, I request you to vacate the decision of the Court of Appeals and affirm the ruling of the juvenile court.
Thank you, Mr. Kempkes. The case of In the Interest of DS then is submitted.